Good morning, everyone. On behalf of British American Business, I'm so pleased to welcome you all to this British American Business webinar on the UK Job Retention Scheme. Some of you may know this seminar is actually part of a wider British American Business COVID-19 offering built around our COVID-19 portal that you can see on our website that is all really designed to help transatlantic companies to manage and navigate the current situation that many of us face. The Job Retention Scheme, announced on the 20th of March by the UK government, can be seen as a grant from HMRC to cover the lower 80% of the employee's regular wage, or £2,500, plus associated contributions to the national insurance. Quite a number of our transatlantic companies have already taken up this offer, but there are also quite a number who are still thinking about whether it is worth considering it. All of these companies, whether they've already taken it up or still considering it, have one thing in common. There are still quite a lot of questions around how can I qualify for it? What happens with my workers if they take up this scheme? Can I bring them back? What are the long-term implications? Many of which we hopefully seek to answer today. I'm very pleased that we have partnered with our colleagues from Charles vs. Speechlys to use the next 50 minutes or so to answer most of these questions. Let me thank first and foremost Emily Chalkley, who covers the employment side at the firm, and Rose Carey, who covers the immigration side at the firm, for taking the time this morning to walk us through some of these points. And I would also like to thank Daniel Rosenberg, who is a partner at the firm, for his long-standing support and contribution to our organization. He has been over 20 years on the British American Business Board. That is quite an achievement, and we're extremely grateful for that. Let me also say a big thank you to not only those who have already sent me a message via the chat room that the IT works, but overall to more than 40 colleagues from within our network for joining us this morning. Gozia, I saw you from Johnson & Johnson, and from ASG. I saw a number of colleagues from McGrath Sheldrick, William from Schroders, Jay from McGrath Capital, I hope you could make it. I also see Sandra from Arnold & Porters, Jason from Knight Frank, Michael from Frank Hirth, Carey from PwC, and many, many others who have been able to join us this morning. Shows us again that this is quite a relevant theme for us to go through. Before we start, let me make a few housekeeping points. We are currently all on mute, but visible for me. If you have any questions or comments, there is a chat section that you can use, and you can anytime throughout the next 50 minutes send a comment or a question that I can consider in my comments or questions to our panelists. The session will also be recorded, so if you want to revisit some of the points being made today, you can do that later. This is an offering for those who have registered and who have received a confirmation from us. And then lastly, please, if your computer allows you to go on mute or unmute, please make sure that you are on mute so that we don't have any background noise. The way we want to run the seminar today is that we have two presentations, one of which will cover the job retention scheme itself, and the other one will cover the immigration perspective to the scheme. And then I also want to invite Rose to say a few things about whether what's currently happening right now has any implication for what is another large topic of ours, the change of the wider UK immigration landscape by the end of the year. I think with that, I've covered my points, and I would like to hand over now to Emily for an introduction of the UK Job Retention Scheme. What would be really interesting here for us to know is, what is it? Who can qualify? How has it gone so far? As I mentioned earlier, we have a few companies who have already taken it up and some companies who are still considering it. So it would be quite interesting for us to know, what do these two groups have to consider separately and together? And who has applied so far? And maybe also a couple comments on the timelines. And with that, Emily, over to you. Again, thank you so much, everyone, for joining. It's great to have you all on this webinar.
Thank you very much. I'm going to share my screen, so hopefully everyone can see the slides. So I'll do that now. Put that. Can everyone see the slides okay? Great. Well, thank you very much. I'm going to cover from an employment perspective, what the job retention scheme actually is, who can apply, who can be furloughed, and then look at some of the kind of trickier issues that haven't really been confirmed by the government or have caused a lot of confusion, but we now have a bit of clarity. And that's around gaining consent from employees to be placed on furlough leave, how you select employees to be placed on furlough leave. Also, the recent clarification which is much welcome about employees who are transferring to a new employer as part of an M&A transaction during this difficult period, and also looking at some kind of wider issues such as enforcement, and also looking at issues for employers where maybe furloughing their workers isn't practical, but other implications that may need to be considered, such as pay cuts and also reduced working. So I'll start with a recap on what the job retention scheme is. I'm sure most of you will have some understanding what the scheme is, what it's intended to do, but I'll kind of run through the headline points at a high level. So it is open for all UK businesses. That includes charities, not-for-profit organisations, providing that they have had a PAYE payroll system set up on or before the 19th of March 2020. Just touching on that, the original government guidance specified the date of the 28th of February. That has shifted to the 19th of March, presumably to try and capture more employees and get more employees onto this furlough scheme, but I'll cover that in more detail later. And it's open for employers who are severely affected by the COVID-19 pandemic. Now, severely affected, what does that mean? It's not really been defined by the government. There's been no specific guidance on what severely affected means. So a lot of employers have been quite cautious. Should I be applying for this? I'm part of a large multinational group of companies. We're not in financial dire straits, but our business is affected. Should we be applying? So the government has helpfully given some indication that it will be applied fairly widely, and it recognises that this pandemic affects businesses in different ways. So we're hoping that that severely affected definition will be applied quite widely. What can be claimed? So an employer can claim under the scheme the lower of 80% of the employee's regular wages. Regular wages doesn't include, say, discretionary bonus, or up to £2,500. So that's the cap for your high earners. Plus, so on top, employers' national insurance contributions, and also the minimum auto-enrolment pension contribution. So if you have an enhanced company pension scheme, you couldn't recover all of that, just the statutory minimum that the government has set under auto-enrolment. It will operate for at least 3 months, so it can be backdated to the 1st of March if employees were not working at that date, and it's open for 3 months, so the end of May, but the government has said that that can be extended. So we expect that that may be extended, but that's still to be seen. Employees can be furloughed for a minimum of 3 weeks. So that's the minimum time employees can be placed on furlough leave. Obviously, they can be placed on furlough leave for the full 3 months if they're not actively working during that period. Who can be furloughed? So this is quite wide. So providing that they are on the payroll on or before the 19th of March. I've mentioned that that date has shifted. What we have noticed is this is obviously a very fast-moving and ever-evolving topic. The government has been issuing succession of guidance, and we are advising clients, and employers are trying to work out what they should be doing based on this guidance. and it is ever evolving. What we had on Wednesday was the Treasury Directive to HMRC. And interestingly, looking at this date change, there is also an added complexity of what they have said is that you can claim the grant for employees who are furloughed, providing they are on the payroll on or before the 19th of March. However, you also need to have notified HMRC under your real-time information that they're on the payroll. So effectively, you need to have run a payroll cycle as well. And that's quite problematic, and I think it may be unintended, because for most employers, they run their payroll at the very end of the month, so it will be after the 19th of March. So actually, they've introduced this date shift to capture more employees, but because of this requirement to have run a payroll, it may not actually capture more employees in practice. That may be an unintended consequence, and that may be rectified in future, but at the moment, we're still waiting for clarification on that. It covers a very wide variety of employees, so not just your full-time, it's part-time, agency, 0 hours workers, flexible workers, foreign nationals, all can be furloughed and providing they're on the payroll. It also covers employees who maybe their employer, the supermarket, has lots of work. It's not it's not that there's a downturn in work, but they are shielding in line with public health guidance, or because the schools have closed, they have child care needs and they need to be at home with their children. These employees can also be furloughed despite the fact that their employer's business hasn't had a downturn in work. And it also covers office holders such as company directors, salaried members of LLPs and agency workers, provided they are paid via PAYE. So moving on to one of the more trickier issues, and this is around consent. So unless the employment contract provides for you to lay off staff, which not many employment contracts do, you need to get the employee's agreement to be placed on furlough leave or furlough status. I've also got in my slides here, or introduce it on notice. Now that's something that has changed as of Wednesday, because the Treasury Directive has confirmed that to place an employee on furlough leave, you need to have their written consent. Now this poses quite a few problems for employers who've had to act very quickly and who have already furloughed lots of staff and have relied on implied consent. So there are many employers, particularly in the retail and leisure industry, such as your restaurant chains, your cafes, where their business is completely shut down, they had to act quickly, they have a huge workforce. Many of these employees don't have their own company email address, and they have sought to rely on implied consent rather than waiting for everyone to email back and express consent in writing. So this has caused a bit of a question mark. We would be saying that for any employers who have relied on implied consent, that they now seek to get written consent from their employees. Hopefully that should be forthcoming, although probably quite a burden from an admin perspective. But the main burning question still remains for that period where you've been relying on implied consent. Are you still eligible for that grant during that period? We would hope so, in the absence of any specific guidance on that, and that this new guidance has only just been introduced. But again, it's still a question mark. Now, lots of questions I get is, what do you do if employees refuse to be furloughed? Employers have the right to top up. So we know that the government will give 80% of salary, or a maximum of 2,500, but an employer can top that up so that employees are receiving 100% of salary if they want to, if they have the funds to do so. So If you are topping up salaries, employees are likely to agree to being furloughed. If employees are receiving 80% of their salary, they're likely to agree to being furloughed. But where you have high earners who are having their salaries capped at 2,500, you may see more resistance there. So what do you do if they can't be furloughed? There are lots of different options, and it may be that you might come to an agreement with them about a salary reduction, or it may be that you have to proceed with dismissing them, offering re-engagement on the new furlough status, and if they refuse, that would create a redundancy situation. That's a very big topic in itself, so I won't go into that into too much detail, but just to let you know, these are the options open to employers if employees refuse. Now, for the clients that I mentioned around restaurants and cafes, it's quite easy. Most of those employees are going to need to be furloughed because there is no work for them to do. But for other businesses, there may have been a downturn in work and you have a reduced requirement for having all your employees coming in and being paid, but you still need some of them to work because there is some business. How do you select those employees? And this can be quite difficult to navigate and can cause resentment between the workforce, because you may have employees who feel like, well, I'm coming in, I'm working, and my colleagues are at home watching Netflix and being paid 80% of their salary or being topped up. And on the flip side, you may have employees thinking, well, why have I been selected? You know, am I less valued? Am I going to be on the front line if redundancies do ultimately need to be made? So that is something that employers are going to have to carefully think about. And the government guidance hasn't put in place any requirement or guidance on how you adopt a fair criteria, but it's obviously going to be subject to existing employment law, such as you can't be discriminatory in the selection of those employees. One possible solution is that you can rotate staff. As I've mentioned, the minimum period to furlough employees is 3 weeks. So you could potentially have 3 weeks on and then employees come back and their counterparts go on furlough leave for 3 weeks. That may be practical in some situations where jobs can be shared. Others, it may not work in practice and you just need continuous employment of one person to support the business need. But that is one possible solution. Working on furlough leave. Most of you will probably know that to be considered furloughed, you must not be working at all for your employer, and that includes a linked organisation, so a group company, but you remain on the books. What can you do while you're on furlough leave? So you can take part in voluntary work, you can undertake training. So that includes, if you're a manager, you can also give internal training to your team. And you can continue with a second job if you already have a second job. But hopefully the guidance has confirmed that you can work for other employers. So if you have been furloughed, if you work for a cafe and you want to go and work for a supermarket, that is possible if the employment contract permits it. So usually you will see in an employment contract, you cannot work for anyone else unless we give you permission to do so. So it will be for the employee to seek consent from their employer to say, can I take up this other job? And that will be permitted, providing the employee is able to return to work when their furlough leave ends. Most employers are giving at least 48 hours notice of when their furlough leave needs to end and they need to come back to work, and that they can participate in any training that the employer is organising during furlough leave. Very briefly, just looking at the recent clarification around TUPE. So where you have an M&A transaction where employees are transferring from one employer to another, there was a lot of concern that these employees would transfer to their new employer and they would not be able to be furloughed because they wouldn't have been employed by that employer on or before the 28th of February, which was the previous date that was required to be on furlough leave. The government has since clarified this and has changed the guidance and said that anyone who TUPE transfers over to a new employer after the 19th of March can still be furloughed, which is good news for businesses. So it means that a lot of these transactions that were due to complete at the end of this financial year should hopefully not be halted because of the uncertainty around furlough leave status. Then just touching on some outstanding questions, which we really haven't got any clear guidance from the government on, and one is notice. So we know that you can be made redundant while you are on furlough leave. You can't use the government grant to pay redundancy pay, but what we're not clear on is, can you serve out your notice whilst on furlough leave? And if you can you receive 80%, the government grant to pay part of that notice? It seems to go against the ethos of the scheme, but we really don't have any clarity on that. And the same is similar with holiday. Can you be on holiday and on furlough leave? There's a lot of conflicting views around holiday at the moment. The ACAS guidance, which is a very helpful guidance, but it isn't law, it's just guidance, suggests that you can, and it suggests that the employer needs to pay 100% or full salary. So if you have taken a pay cut to be placed on furlough leave, if you're taking holiday, the employer should be paying your pre-furlough pay. But again, no clear guidance on this. And then a big question is around enforcement. So we know that HMRC retains the right to retrospectively audit companies around these claims, but we don't know what those audits are going to look like in practice. We don't know what the penalties are going to be for abuse of the system or getting things wrong. What we do know is employers are being advised to keep records for at least 5 years. And then just very quickly, some employers will need their staff to continue working. They will still have work to do, but they will be in a very difficult financial position during this period. And they may be needing to look at temporary cost savings. So what we are seeing as an alternative to furlough leave is many employers are asking their staff to take pay cuts or reduced hours on a temporary basis. And this is obviously a fundamental change to the employee's terms and conditions. So this needs to be navigated lawfully, and you will need to get their express consent to vary these terms and undergo a period of consultation to do so. I'm going to hand over to Rose now, who will look at the immigration issues.
Emily, if I just may jump in, please, and say big thanks to your presentation. We like to keep things tangible, and I've just looked into our questions section, and there were a couple of questions to some of the points that you mentioned. And if you don't mind, I would just ask them straight away, because that would make a lot of sense before we switch over to the immigration side. I picked two of those, and the one question we just received was whether the size of the company matters. We have colleagues on the call who represent companies with thousands of employees. We also have colleagues on the call who have 10 or 20 employees. And there was a question whether size matters. And that may be a perception question, or maybe also a technical question. For example, can a company with 5,000 employees use the scheme for, let's say, half of their staff? Would that make a difference to a company that has 20 employees and says maybe 5 of their staff should go on furlough? That's the first question.
So the answer is no, it doesn't matter. So anyone who has staff on and has their payroll system set up, they can be eligible for the scheme. I guess the size of the company only really comes into question around this severely affected. If you are a huge company and your finances are in good order, that may go to the question of, are you severely affected? But no, the size of the company has no bearing on whether you are eligible or not.
Thank you. And the second question, picking up on what you just said, I have a business here who says that when the crisis started, they really did their best to keep the business stable, and that because they had the house in order, they were able to do so. But now they feel more and more that they may actually have to look into cost-saving measures, and we're therefore also looking into the government UK job retention scheme. Now, the question was that, are they too late? Because right now it says that the scheme may expire end of May, and so the question here is, if I have an employee whose salary cycle starts 1st of May, would I be too late if I wanted to put him or her or a number of employees on furlough? And is there a chance that the scheme will actually eventually be extended?
Yeah, so there is no deadline. So the online portal is actually due to open on the 20th of April. And so if you were looking to furlough employees now, that isn't a problem. You should be able to furlough them, providing you're eligible, to the end of the scheme. And I think given that the government announcement that lockdown has been extended, it is quite possible that the scheme will be extended as well beyond the end of May.
And you say there will be a portal for companies to use as of 20th
Yes.
of April?
Yes, so that is a portal on HMRC's website. It hasn't been open yet, so employers who have furloughed staff already will all be seeking to effectively upload their online claim on this HMRC portal, which is due to open on the 20th of April.
Okay, and companies, that would be the last question for now, and I will get back to the other questions later. If the portal is not due to open until the 20th of April, how would I have done it otherwise already if I had decided earlier this month to put someone on furlough?
So so they would still be on furlough status. It's just that you physically can't apply for the grant until this portal is open, but it doesn't affect for the period you can you apply for the grant from, providing that those staff have been on furlough leave for that whole period.
So can you do this retrospectively? Could you say, I put someone on furlough at 1st of April and then apply through the portal and pretty much have it start? Okay.
Absolutely.
And do you have to prove legal evidence that this person was actually on furlough?
Yes. So not at the point of the on the portal, but this is to do with the retrospective audit that HMRCs can do. So you don't necessarily have to produce the evidence on your claim on the portal, but you will need to retain records and evidence if HMRC decide that they're going to audit your business retrospectively.
Fantastic, thank you. We are good in time, so I will allow for one more question, and I really appreciate our audience being so active. I know it's a different format than in person, but I really feel it works quite well. The question here is, the case situation is the following. There is an employee who has been in a full-time employment with an employer, and this employer decided to make this employee redundant early March, saying that this is not related to the COVID situation. So the employee now is wondering whether there is a way for, in this case, an employee to make a case of his employer to say, well, actually, there would have been a protection scheme in place. Can you not use that? Is there any way for the employer to get back to, for the employee to go back to his employer and use what is currently in place to potentially find a different path for this employee?
Yeah, so the government have clarified that you can rehire staff to place them on furlough leave, and they have confirmed that you can rehire them even if their redundancy or dismissal wasn't related to COVID-19. It does throw up some difficult questions on whether that employee will have continuous service. So you acquire maybe unfair dismissal rights that they didn't have. They will be accruing holiday during that period if they've been paid a redundancy payment already. What happens when they come out of furlough leave and need to be effectively dismissed again. So the government has confirmed that you can rehire for whatever reason and place these employees on furlough leave, but lots of wider questions on the implications for the employees doing so.
Thank you so much for embracing these questions right away. That was extremely useful. We have a few more which I will address later on, but I'll leave it now to you, Emily, to hand over to Rose for the second part of the presentation.
Yeah. Well, hi, good morning, everyone. Thanks, Emily. That was really interesting. I'm now going to try and share my screen as well. Let's hope this works. Here we go. Can I just check that you can see my screen and see the slides? Wonderful.
Yes, we can see it, and we get also comments from participants that we can see it.
Wonderful, thank you. So let me just move to the first immigration slide. Here we are. So we've seen from Emily's presentation that there's a lack of clarity in the guidance that has been issued. And it's the same with the guidance that's been issued by UK Visas and Immigration in relation to what happens to workers in the UK who are on visas and whether they can benefit from the job retention scheme. Interestingly, their guidance doesn't make reference to that scheme by name, but what it does reference is the ability to reduce the pay of sponsored employees. So that's employees who are sponsored under Tier 2 or Tier 5, so they're on a particular visa. And as you can see, it follows the job retention scheme requirements in terms of the maximum reduction. So it is effectively the same. They just forgot to mention job retention scheme in the guidance. And we have seen from HMRC, which is much more helpful, confirmation that you can furlough employees who are on all categories of visa, which would include Tier 2 visas. And Tier 2 visa is a visa that ties an employee to a particular employer. The employer is the sponsor of their visa. And that does have a lot of restrictions around salary reductions and changes to employment. So there was a lot of confusion as to whether Tier 2 workers could benefit from the job retention scheme. So we have seen from HMRC, yes, they can, and also from UK Visas and Immigration, although perhaps not as clear and not as helpful. And the other question we often see with migrant workers on visas is whether the job retention scheme would be classed as a public fund. Now, the reason why we've had questions about that is because migrant workers are not allowed to claim public funds in most cases. So there was concern as to whether it would be a public fund. I can confirm that it is not a public fund, and they are able to benefit from the job retention scheme. So that's good news. They can be treated the same as other employees, and they can be furloughed. Interestingly, for business owners who are on Tier 1 entrepreneur visas, and we do have a lot of US clients on that visa in particular, they have a requirement in order to extend or apply for their settled status that they must have employed resident workers for 12 months. Furlough staff will not count towards that job creation criteria, but the guidance from UK VI does confirm that they will be given a temporary extension in order to enable them to meet the criteria. So that's good news for any business owners out there. And then one of the things that Emily talked about in her last slide was about pay cuts and reduced hours. And she said that from an employment perspective, that can throw up quite a few issues. And it's the same for immigration as well, particularly for Tier 2 workers. And that's because, as I've said in the previous slide, there are lots of restrictions around changing their duties, changing their job, reducing pay and hours. And it is a problem usually to make changes to a Tier 2 worker's salary if it falls below the appropriate rate. Now, this is something that depends on the type of Tier 2 visa they have and the particular job they're doing. So the appropriate rate will vary depending on whether they're a Tier 2 intercompany transfer or they're a Tier 2 general, and also the type of job they're doing. So the more skilled and senior the role, the higher the minimum salary will be. So the appropriate rates could be higher for that type of role than, say, a more junior role. And reducing salary below the appropriate rate is a problem in Tier 2. The exception to that, of course, will be if they're furloughed. As we've seen from HMRC guidance, it is possible to furlough a Tier 2 worker. So if their salary is falling below the appropriate rate because they've been furloughed, then although UKVI guidance doesn't say this, it should be acceptable because it has been confirmed that they can be furloughed, and then there's no guidance to say that it's a problem if their salary falls below the appropriate rate. So we are working on the basis that in these exceptional times, if they're furloughed and it falls below the appropriate rate, that will be acceptable. However, if you're reducing salary and it's not under the job retention scheme, be very careful, because that might be a problem, and you will need to check carefully if it's going to fall below the appropriate rate or not. And the other visa category that may have problems with a reduction in pay are those on what we call Appendix FM visas. So these are family visas. So they're a family member of a British national or someone who's settled in the UK. That has a minimum financial requirements. They either have to show a certain amount of savings or income of a minimum of 18,600 in most cases. And therefore, if their salary is reduced and that their salary falls below that, that might be a problem later on down the line. However, although the Home Office, UK Visas and Immigration haven't clarified this, we would expect them to exercise discretion in that situation if that happens. Importantly, you have to ensure that you retain evidence, and this is something that Emily talked about as well. So not only could you be checked, audited by HMRC, UK Visas and Immigration could also conduct audits of Tier 2 sponsor license holders. So if you are furloughing Tier 2 staff, it's really important that you keep records and you make a report via your sponsor management system to confirm the reduction in salary, to confirm if it's part of the job retention scheme, and to keep a record of those employees who have had their salaries reduced, and then also to make a further report via your sponsor management system once the arrangements have ended and their salary has returned to the previous level. It is advisable to return salary to the previous level. Going forward, some businesses may need to take long-term decisions about potential reductions in salary and what to do around that, depending on business needs and maybe redundancies and various considerations they will have going forward. You have to be very careful with Tier 2 workers in terms of making changes, and so it's always advisable to take advice before you make any changes to Tier 2 workers once the arrangements have ended. So other issues for Tier 2 workers, sponsors no longer need to report an absence or remote working. That is normally a requirement. If a Tier 2 worker is changing their work location or they're going to be absent from work for a period of time, that usually has to be reported. There is no need to make the report. However, you should still keep a record so you are aware. If you're audited, you will be able to provide the information. There is also no need to withdraw sponsorship if the Tier 2 employee is absent from work without pay for 4 weeks or more. Previously, it would actually invalidate sponsorship, and the employer would have to make the report that sponsorship has been invalidated because their employee has taken 4 weeks or more unpaid leave. That requirement has been temporarily suspended. So if an employee is on unpaid leave for 4 weeks or more, it will not automatically invalidate their sponsorship. But however, as we saw in the earlier slide, it might be a problem if the salary drops below the appropriate rate. UKVI will not take any compliance action at the moment because of the COVID-19 outbreak, so they will not be taking any compliance visits to clients' offices, although there wouldn't be anyone there, so practically they wouldn't be able to do that anyway. They are not undertaking any enforcement action either, so that's all on hold at the moment. However, that of course will commence again once the situation has passed. The other issue for Tier 2 workers, and also actually most migrants in the UK, is the absence limit for settlement. So when someone wants to apply for their indefinite leave to remain, their settled status in the UK, they have to meet a requirement that their absences are no more than 180 days in each year of the period of residence, which is normally 5 years. So we may be in the position where some employees are abroad and are unable to return to the UK, and so their absences may go over the 180-day limit. We are expecting UKVI to exercise discretion. They already have the ability to exercise discretion for excess absences for natural disasters or for humanitarian rescue operations. So we're expecting that to apply to this situation as well. It's also the same for British citizenship. Anyone applying for citizenship has to meet residence requirements. We are expecting discretion to be exercised if someone doesn't meet the residence requirements because of excess absences during this time. And another concession has been to allow employees to start work before their visa application has been decided. So this will apply if someone is in the UK and you have sponsored them, so you've issued the certificate of sponsorship, and they are waiting for their application for the new visa to be approved. In that situation, as long as they will be doing the role for which the certificate of sponsorship has been issued, even though their visa has not yet been approved, you can actually go ahead and employ them. One of the big complications we're seeing at the moment in immigration is the closure of visa centres. So outside the UK, they are all UK visa processing centres are closed. They have often retained visas and passports, so it means that clients are unable to get their passports back in many cases, and so they are stuck in their country of origin, waiting for the return of their passports. Also, the visas are only issued for up to 30 days because they are a temporary visa for entry purposes, and then once in the UK, the individual would pick up their full status immigration document. The difficulty we have at the moment is by the time the passport has been returned to clients, that 30-day visa has actually expired already because it's taken so long to get the passport back. And in many cases, they are still waiting to get the passport back, and they're unable to get the passports back due to lockdown. So it's unclear what will happen once this ends, if clients are going to have to reapply to get a replacement visa. Normally, that would be the situation. And pay a fee, which would be, I think, unfair in these circumstances to expect people to do that, or whether some sort of special policy will be introduced to reissue the visas without further fees and without further applications. So we're waiting for further guidance on that. Application centres in the UK are now also closed. So the third party that has the contract with UK Visas and Immigration is called Soprasteria. They do all the biometric processing, which is key to filing an application in the UK. So the application can't be progressed until biometric information has been taken. And at the moment, that is not possible to complete because all the centres are closed. We're also seeing for settlement and citizenship applications some issues because the test centres have closed. So clients who were about to apply for their settlement, their indefinite leave to remain, and clients who are about to apply for citizenship, they have been unable to do that because they have been unable to take the tests that they need to take to prove they have passed the Life in the UK test and meet the English language requirements. We are advising clients in that situation to submit their applications anyway, and then send follow-up test results later. The important thing is to get the application in, particularly those who are applying for settlements, and you can follow up with the evidence later. And one of the key things we're advising clients is to make sure that applications are made before visa expiry. So anyone in the UK seeking to extend should do so before their current visa expires. And the reason why that's important is because overstaying is actually a criminal offence. It also will affect right to work. One of the things that UK Visas and Immigration has confirmed is that anyone who's here who is unable to leave, so for example, perhaps they're a business visitor visiting the UK office, and they, for whatever reason, have been unable to return home, they are able to get a visa, an automatic visa extension, which will take them up to 31st of May 2020. It's possible, depending on what happens with lockdown, that date may be extended. In that situation, though, they should still contact the coronavirus team at the Home Office to confirm that they are unable to leave the UK and to provide evidence where possible, such as flight cancellations. Any employees who are due to extend should do so before their visa expires. And in order to extend, even though the centres are closed, you can extend and get your application filed in time if the form is completed and the visa fee is paid. So even though the appointment can't take place until lockdown ends, technically their application has been filed in time. So it's really important that employees are doing that where their visas are about to expire. There's also some increased flexibility on switching applications. Normally there are strict rules around someone who is in the UK applying to move visas, and there are restrictions around who can do that and which visas they can move into. They have been relaxed, so it is possible in theory for, say, someone who's here as a visitor to switch into Tier 2 if they are unable to return home due to the coronavirus situation and inability to travel. Another change which is helpful for employers is around right to work checks. With lockdown, it's very difficult now to conduct right to work checks because usually the original has to be seen in the presence of the employee. So it is possible now to either do a virtual check or to run a check with the Home Office, which is an online right to work check. And the link is there in the first bullet point. It's important to get the employee's permission for GDPR purposes because you will be sharing their data. But you can run a check with the Home Office if they have a biometric residence permit or biometric residence card, or have pre-settled or settled status under the EU settlement scheme. You can run that online check and get confirmation of their right to work, which would cover you. If that is not possible, or as an alternative, you could do a virtual right to work check. So this would mean you would need the employee to send you a copy of their right to work documents, and then you would have a video call so you could also see the employee with their right to work documents, so for example their passport. And then you should make a note that you have conducted the check in that way, as you have a record. And then as soon as the lockdown ends, and within 8 weeks of the ending of the lockdown, you need to conduct a full right to work check, which would mean seeing the original right to work document in the presence of that employee, taking a further copy, and then signing and dating those copies, and then putting them on the personnel file. And then very quickly, in terms of EEA workers, we do get some questions about their position. It's the same, there's no change at the moment. They have rights of free movement until the end of the transitional period, which is on the 31st of December 2020. They are treated the same as British workers. Any EU, EEA or Swiss national who is resident in the UK before 31st of December 2020 can apply on the EU settlement scheme. So if they've lived here 5 years, they can get settled status straight away, subject to meeting residence requirements. If they haven't been here that long, or perhaps they've just come to the UK, they can get pre-settled status, and that enables them to live and work in the UK visa-free for 5 years. That pre-settled status will be valid for 5 years. One of the complications has been that we have previously been advising clients to bring forward recruitment of European workers, to bring them in before the end of the transitional period, so they can benefit from this EU settlement scheme and get their 5-year pre-settled status. Because if they come after January, they will be subject to the immigration system and will need a visa. So we have been advising employers to bring forward recruitment. However, with COVID-19 and restrictions around travel, that may no longer be possible. So from 1st of January 21, we will see the new immigration system. It's not really a new immigration system, actually. It's tweaks to the existing system and the introduction or reintroduction of some old visas that were removed a few years ago. One of the benefits is opening up Tier 2, so it's less restrictive. There will be a reduction in the minimum salary that is required, removal of the resident labour market test. This is where employers have to advertise the role to justify why they are recruiting a migrant worker and not someone from the UK. And lowering of the skill level. Currently, sponsorship is limited to RQF level 6 roles in most cases. That's effectively a graduate level role, so you're looking at something professional, managerial level. That will be reduced to level 3. So for example, a restaurant manager would come under level 3. A business development executive would come under level 4. They would all be possible from the 1st of January. And interestingly, we may see the reintroduction of the highly skilled migrant visa later next year, which is a visa for people with certain academic qualifications and skills and experience. And it's likely to follow the old highly skilled migrant program that was in place many years ago. So it's probably going to be a reintroduction of that. And then Tier 1 post-study work, which is a 2-year working visa for UK graduates, will come in from 21. Some of the problems with the new system, the cost of Tier 2 visas, because EU nationals will fall under Tier 2 in most cases, it means employers are going to have to bear the cost of issuing those visas, paying for those visas for more staff than anticipated. So the cost of a 3-year Tier 2 visa is around £6,000 with all the various charges. And if they were bringing family members, that's probably going to be around £2,500 per family member. There are lots of different charges involved, like the immigration health surcharge, which is £400 for each year of the visa, and the immigration skills charge, which could be £1,000 for each year of the visa. So all these charges add up. So if you've got one worker plus spouse and 2 children, you're looking at around £13,000 potentially. Most employers will often pay all the visa fees, but I think employers are going to have to think about whether they're going to do that going forward. And one of the other big issues around the new system is the lack of visas for lower skilled work. And we're seeing that really highlighted at the moment with the lockdown, how important our migrant workers have been in hospitality, in retail, in healthcare. Many of those roles would not qualify for Tier 2 sponsorship. They're not as high as level 3, and that is a problem for many industries, particularly hospitality, retail, food and beverage. And that brings me to the end of the immigration presentation.
Well, thank you so much, Rose. And while we bring Emily back, let me say 2 things. First of all, thank you so much for what I thought was an extremely informative presentation, particularly when it comes to Tier 2 in the context of the current government scheme. We as British American business actually hadn't seen much information out there. So with your permission, we would love to make sure that this is being available to the many, many companies that we're supposed to serve. This is, by the way, an offering that we make to many of our partners within our network, that wherever we find useful information, our job is to make sure that this is available and visible to those who need it. The second thing I wanted to say, we will probably run a few minutes over time. With our audience permission, please feel free to stay on and continue asking your questions or my comments. If you have to leave, what is of course available is that you can connect with us after the seminar, either with our panelists and speakers in front of us, or with British American Business, and we can afterwards facilitate an introduction. I have right now 4 more questions that I would like to put to you. One of which is more of a confirmation for you, Rose. A company that says that they have an American citizen as an employee currently on a spousal visa and up for renewal. Application has been submitted, but the renewal has not been granted. So now what's now happening for this company is that for the accounting department, a message pops up that this worker may lose the right to work. Based on your presentation, would you say that this company is for the moment safe, given that the application has been submitted, the pay had been feed, but the fee has been paid, but actually the visa has not been issued yet?
Yes, that's right. As long as their application was made in time, so the form and fee paid before their visa expired, it's in time, and so their right to work would also continue. However, the employer is meant to conduct a repeat right to work check for anyone whose visa is being renewed, which they won't be able to do at the moment because they won't have the document, but they can use the employer checking service at the Home Office, and that is something they definitely should do. So they would need to get the employee's permission for GDPR purposes, but they can contact, it's all done online. It takes about 5 minutes, and the link was in my slide. They can run the check with the employer checking service, and they will get what's called a positive verification notice, which will cover them for 6 months.
Fantastic.
So
thank you so much.
A right to work check for 6 months if they do that.
That is very reassuring. Thank you so much. I have a question for Emily, actually 2, and one maybe for the 2 of you. One of which is that we have a company here who says, would that send the wrong signal? I mean, that may be a more theoretical question, but would it send the wrong signal if I put workers on furlough? Would I actually rather have to look into redundancy, given that this can be a long-term situation, or should I try to avoid it altogether, given that other colleagues may be worried that furlough will lead to redundancy?
Yeah, I think it is a bit of a tricky one, but I think the primary objective needs to be you looking at your business planning. This is a government grant. Many employers are taking this up because it is a lifeline for their business to stay financially sound during this difficult period. On the selection process, if you are worried that it sends a message that employees are going to be picked for redundancy, I think it's just making a reassurance that this is furlough leave, this isn't redundancy, it's a different process.
Okay, thank you very much. I have one more question for you, Emily, and then a question for the two of you, which may be the final one for today. The question I have for you, Emily, is whether you know what the process for banks is to administer the furlough pay, and how do the banks determine which business they can work with?
In terms of where is that for their own? Do you know if that's for their own employees or working as a partner? So
what let me do, let me just see, because there's just a follow-up. Now what I will do is I will just ask whoever just submitted the question on the banks and how they administer the furlough pay, whether there could be an additional clarification, please, for Emily to answer. In the meantime, the question for the two of you would be, we have a number of companies on the call and in the network who are foreign headquartered or foreign owned. Is there a difference between a UK headquartered entity and a foreign entity that may have only a branch in the UK when they consider taking up the job retention scheme?
So from an employment perspective, if they have a UK subsidiary, so they're a UK business with a PAYE system, then they can still apply for the furlough scheme, the job retention scheme.
And Rose, the same would apply to foreign entities who have tier 2 workers or people on an investor visa in the UK. That would make no difference as long as they are somehow registered in the UK.
Yes, that's right. So in order to be sponsored in tier 2, there has to be a UK entity, but it could be a branch rather than a subsidiary potentially. So if they're on a tier 2, then there will be a UK entity that's sponsoring them anyway, even if it is headquartered overseas. So yes, they can still be furloughed.
Okay, I will ask whoever submitted the question on the banks just to send it to us privately so that we can process your inquiry, given that I haven't seen a follow-up yet. And we'll conclude with a final question, which I think maybe also for you, Emily, is should employers expect difficulty in processing any furlough applications, given that the portal is only live on the 20th of April, and we may expect a high volume of requests? What do I do if that is happening?
Yeah, so I think it's probably right that when the portal opens, that many employers are going to be trying to submit their claims as quickly as possible, because the sooner they submit, the sooner they get their grant. I guess it's a real uncertainty whether the portal that's been set up is going to be able to cope with that pressure or not, and what technical hitches are going to occur. But I think that there has been a delay in actually setting up the portal, so hopefully that has been put together well, and the government have thought about the portal and that it's easy to access, etc.
Thank you very much. And I would assume, I mean, based on your insightful presentations just now, I mean, this is exactly the kind of offering that your company would provide if companies do struggle with either of these, whether it's tier 2 workers currently subject to the scheme, or any other worker that works for a UK entity. You could help these companies process and to pretty much navigate what needs to be done, and also what you mentioned, the number of unsolved questions that are currently still out there.
Yeah, absolutely.
Fantastic. I think I have covered all the questions that have been submitted. So what I would like to do is to say again, thank you very much to our audience, who has been extremely patient and persistent to stay over time. for joining this morning. It was really great to see so many of partners and colleagues that we know from a variety of firms. I would like to really say a big thanks to you, Emily and Rose, for what I thought was an extremely impressive presentation. Speaking of which, we had just a couple of inquiries as to whether this presentation can be shared with some of those who joined this morning, or whether this is confidential. So you can let us know, and we can make this part of the follow-up email that we will send. And we know, of course, that not everything may be able to be shared. But in any case, that was extremely impressive, extremely interesting. We would love to continue working with you and making sure that as many people as possible know that this information is out there. Let me say a big thanks to the team to put this together in a very short time, and everyone who was involved today in making this possible.
Thank you.
Great to have you all. Have a good rest of the day and a good weekend to come.
Bye-bye. Take care. Bye-bye.